Hello, everyone. My name is Don Self. Today, we're going to be talking about a problem that a lot of offices are having right now, and that is all of the record requests that they're getting from the insurance carriers. It seems like in the last year or so, and this is 2025, the number of record requests has been amazing. It's just been ridiculous, honestly, if you're looking for the right word, because the carriers are doing record requests for either HCC or they're either doing a record request so that they can downcode you or something. So today we're going to be talking about, again, HIPAA compliance and are they being compliant whenever they're doing these record requests? Often, I believe they're not, and we're going to go over that. So, HIPAA compliance versus payer demands, and what you must know, what you need to know. To begin with, I've been doing seminars. This is my 41st year in working with physicians, consulting, writing books, seminars, etc. And I'm extremely blessed to get to keep doing what I'm doing. A lot of times, your practice can be guilty of violating different regulations or laws, and you might not even know it. For instance, you could be violating HIPAA without knowing what the law is. So whenever you go to send the records to Optum, Seox, Change, Codaviti, all these others right here, and they're asking you for thousands of records, it seems like, okay? And you're responsible for following the laws on each one that you send. Sometimes they're coming back and asking you for dozens of records on dozens of patients, or they may be asking for even hundreds. I saw one client in Tennessee that they were asked for 300 records, like 366 records. And each one of those was not just for one date of service. Each one of those was for a full year. And volume of them doing this does not equal legitimacy. They just because they're doing it doesn't mean that they can get away with it or that they're within the law when they do it. They still require, HIPAA still requires that you follow minimum necessary disclosures. And we're going to go over that right there. We're going to be referencing the different Code of Federal Regulations at times, like CFR 164-502B, that basically says it's your job to evaluate every request to find out if it's being compliant or not. Now, sometimes these carriers, they don't mean to be violating HIPAA, or it may be even that you're talking to someone that doesn't even know what the HIPAA laws are. But whose responsibility is it to determine what's medically necessary or what's minimum necessary? That's you, not the person requesting the information. It's you because you're the one that's the custodian of the patient's PHI. And when I say minimum necessary, what exactly is the minimum necessary requirement? If you look at CMS, I'm sorry, the HIPAA laws, it says a covered entity must develop policies and procedures that reasonably limit its disclosures of and requests for protected health information for payment and healthcare operations to the minimum necessary. Now, again, who's the one that's being tasked with that responsibility? You're the covered entity. You're the one that's holding the records. It is not the insurance company's responsibility to determine what minimum necessary is. It's you. So does a full year records reflect minimum necessary? No, it really doesn't. By the way, anywhere you see the links right here, you're going to see a way that you can download those. I'm sorry, you'll be able to click on them on the PDFs. So who pays the price if you're not following the HIPAA? It's not going to be the insurance company that's requesting the information, that's threatening you, etc. It's going to be you. Office of Civil Rights, part of H&HS, which is part of, the federal government right here. When they go to investigate, they're going to be investigating you. And who's going to be the one that's going to be fined if they find that you violated HIPAA? You. So you've got to be careful about this. Now, where can you verify this right here? You click on here on this link that on the PDF that basically shows you what the privacy and guidance rules are for HHS HIPAA. And it's basically going through and saying who can disclose. And if you look at the wording in that, where it says uses and disclosures for treatment, payment, and healthcare operations, you're going to find it says exactly. A covered entity must develop policies and procedures that reasonably limit, that's what I went over a few minutes ago right here with you, its disclosures of and requests for PHI for payment and healthcare operations to the minimum necessary. A covered entity also is required to develop role-based access policies and procedures that limit which members of its workforce may have access to the PHI. And then you go on down where it says here in the little arrow, consent. A covered entity may voluntarily choose, but is not required to obtain the individual's consent for it to use and disclose information about him or her for treatment, payment, and healthcare operations. A covered entity that chooses to have a consent process has complete discretion under the privacy rule to design a process that works best for its business and consumers. That's you. You're the covered entity that needs to develop the right kind of a policy in your office. So if you have doubts whether or not a request meets HIPAA requirements and their minimum necessary, or whether or not the patient's aware that the insurance company is requesting this many records, it's up to you to make that determination. It's up to you to reach out to the patient. A consent document is not a valid permission to use or disclose PHI for a purpose that requires an authorization under the privacy rule, or where other requirements or conditions exist under the rule. And we're going to be talking about some of those other requirements. It's not just, okay, I have permission from the patient to request this from you. I'm the insurance company, and the patient signed this saying that I can request anything I want anytime I want it. And that's what they would like you to believe. It's up to you, though, because you're the one that has the complete discretion. And I want to stress that right there, to design a process that works best for your business and your consumers. But the carrier says that I have some kind of agreement with them. Your contract never violates or cannot trump or supersede federal law. HIPAA law always rules over any kind of an agreement you may have. You cannot enter into an agreement to violate any federal law, and especially 45 CFR 164-502 or 506. And those are the HIPAA Privacy and Security Acts. HIPAA is federal law, and it supersedes, again, all private payer contracts, the ones between you and the insurance company, the ones between the patient and the insurance company, by the way. HIPAA federal law trumps all of that right there. And courts have ruled on multiple occasions, federal courts have, contracts cannot compel illegal conduct. You cannot go into some kind of a contract to say, I'm going to perform something that's illegal and I'm being held to that contract right here. If your contract somehow contradicts HIPAA, HIPAA is going to win every single time. And remember, your signature on that contract, it does not erase the law. All it does is make you liable for violating it. Sometimes, why do we give the payers direct access to your EMR? They're going to ask you, hey, if it's too much work for you to make all these copies of these 75 records we want for 1 year's records, just give us login access into your EMR and we'll log in and get those right there. That's a surefire way of making sure you violate HIPAA. There's no way in the world I'm going to let the fox into the hen house and get that data because they're going to have access to other patients' data of other insurance companies whenever they have access into your system. Don't do that right there. Well, let us come into your office and we'll just make the copies in your office. No. HIPAA requires you, the provider, to control access to that PHI, not the patient, not the payer. It's you. You're the one that's being responsible for that. And you're responsible for what they're going to be viewing, even if you didn't mean to disclose it. Minimum necessary standard does not allow an open book access. I can't just come in and look at everything. And you say, but what about the business associate agreement? Doesn't that do it? No, you're still dead in the water right here if they violate it. You're still the one in trouble. And letting a payer into your electronic medical records or electronic health records, giving them unlimited disclosure, no. It would be the same thing as you handing them your house keys and say, hey, go get whatever you want out of my house. You wouldn't do that with complete strangers. At least I hope you wouldn't. Now, what is the compliance chain of command when we're talking about being compliant? The bottom of the heap up there is the provider carrier agreement. Yeah, that agreement that you signed with the insurance company or your doctor or your administrator at your hospital, or whoever you are, what kind of an entity you are, that agreement, that's the bottom. Above that, excuse me, is a patient's insurance plan. You say, well, what if I've agreed to something in my plan? Doesn't that somehow trump the patient's insurance? No. In fact, that patient's insurance plan is protected by not only federal law, but also state laws. And then that's the order of authority. You start at the feds, then the states, then the patient's insurance plan. And at the bottom of again, the heap is your contract with the insurance company. That's why I always tell people, that 90-day agreement you have with United Healthcare to get those claims in doesn't matter because that patient's policy overrides that. And by the way, the federal law overrides that says there is no timely filing that's enforceable. That 90-day or 120-day appeal period that you have, that you signed with a provider or carrier agreement, it cannot be a minimum. It cannot be under 180 days. That's federal law. So that means that the contracts that you're signing with these carriers are not set in stone, folks. By the way, sometimes if you read these letters that they're sending you, they're being actually honest on a couple of things. Like it says right here, this was an actual copy out of one of the letters that one of my clients received. Health information is personal and protected under the law. All PHI transmitted in this facsimile is done so with appropriate authorization and does not require said authorization. But it also says the recipient of this facsimile is responsible to protect PHI in accordance with all state and federal laws. Failure to do so may subject you to all penalties. And they're being honest about that one statement right there. So be careful. Don't sit there and say, well, that means they've requested it, I have to send it. What do the federal laws actually state, though? If you go to the Code of Federal Regulations, go to 45, and that's all regulations governing the different government entities are found in the Code of Federal Regulations, and you can access those at ecfr.gov. But 164.501 says prior to sharing PHI with another covered entity, you must follow the two requirements. Unfortunately, most people are not familiar with the two requirements. In fact, I'll guarantee you many times the people asking you for the information at the insurance company, they're not familiar with the two requirements right there. So what are these two requirements right here? And if you go to 506.C4, it says if you disclose PHI to another covered entity like Optum, Seox, Codaviti, etc., for healthcare operations, both entities must have or have had a relationship with the patient. Now, you're one entity. You're the first entity because you're the one possessing the patient's information, the PHI. You're the custodian of that patient's records. You're the one that's responsible for protecting that patient's records. So you're the first entity. Who is the second one? If they're asking you to send it to Optum or Seox or Codaviti or whoever it is, they're the second entity. So do they have a relationship with the patient? If you picked up the phone and called the patient and said, hey, do you have a relationship with Optum? They're asking me for some of your medical records. They're going to say, who the heck is Optum? Well, isn't that your insurance company? No, I got United Healthcare. But is it Optum some kind of a contractor of them? Yeah. A contractor or third-party vendor has never treated the patient or delivered a service, so they do not have a direct relationship with that patient. So it's up to you, by the way, to determine whether there's a direct relationship or not, or whether or not you are legally allowed to give them that information. So if you wrongly disclose PHI, you're going to be the one that's going to be investigated and fined or penalized, even if the request came from an insurance company. Maybe you get a letter from Aetna saying, hey, uh, this Seox company or this Codaviti or this Change company or whatever it may be, it does our audits for us. So we're asking you to send these records to them. And we have a business associate agreement with them. Well, have you looked at that business associate agreement? Are you sure there is one? Just because they say something doesn't make it so. It's kind of like the internet or social media. You see it on social media. Is it true? I doubt it with all the robots out there anymore and with all the AI stuff. You can't even trust your own eyes anymore. So you look at something. As it says under 506, it's the provider's legal duty to ensure the PHI disclosures are lawful, and only to those entities that have a valid patient relationship. That's what it says in 506. So you got to make sure you're following it. But you say, isn't Optum and United Healthcare the same company? Optum Episource LLC on behalf of United Healthcare. Well, United Healthcare is an insurance arm. It's a health benefits company, and Optum is a services arm focusing on things like data analytics. They're all owned by United Health Group. But that's like saying two siblings are the same person. I've got a 12-year, a sister that's 12 years younger than me. Because we share parents, we're not the same sibling, we're not the same person. They're separate corporations with different tax IDs, different executives, and different roles in healthcare. So, are they the same entity? No. Does the patient have a relationship with that entity? And that's where you have to ask that question. If a provider is being asked to send the PHI to Optum, it's up to you to confirm that the patient has or does not have a relationship with Optum, not just United Healthcare. Otherwise, you may be violating the federal regulations. I mean, you take a look at these two brothers right here, United Healthcare and Optum, and United Health Group Ranch. Okay? Same ranch, different jobs. Don't mix up the brothers right here, folks. They could be completely different right here. Now, why does this all matter? As I said, under HIPAA's disclosure rules, sharing PHI between entities for operations like risk scoring or utilization management or care coordination requires that both entities have or have had a relationship. You say, Don, you said that like 4 times. Exactly. I'm trying to get that into so that you'll understand. That's one of the two requirements right here, that they have or have had a relationship. So does Optum have a treatment or service relationship with the patient? It's up to you. Now, the letter says they have it. The provider's absolutely within your rights, by the way, to demand to see it. In fact, it's your responsibility, not just your rights, but it's your responsibility. A mere claim that a BAA exists does not override your responsibility to protect the PHI. So let's say you get a letter from Optum or Episource or Change or whoever it may be. I mean, there's a bunch of different companies out there. Some of these I've never heard of before, like Fatica Health or Telligen or Apixio, etc. Are they valid? Are they always valid? Well, I got this letter right here. Take a look at this letter right here. This appears to come from CMS. This was a demand letter requesting or demanding records under 45.371, which I have no idea what 453.71 is. Do you? Okay. And this went to a doctor, and the doctor's name has been blacked out on this right here because this fax came in, and they were requiring complete medical records for, what was it, 6 months of the year, 1/1/2025 to 6/17/2025. That's this year. Signed patient authorizations, itemized billing. In other words, they wanted to see the UB04s, the 1500s. They want to see what are the supporting diagnostics, imaging, etc. And they want you to fax it to this phone number. Is this valid? By the way, that phone number is in Canada. And I guarantee you, CMS is not asking you to send records to Canada. And the consequences of oh man, they're going to try to scare you. Automatic payment suspension under 405.371. NPI deactivation. We're going to get rid of your NPI number and make it not. And this is not a routine audit. Failure to comply will be interpreted as willful obstruction. No extensions, no exceptions. This is a fake letter, but yet this was received by a medical office up in the northeast part of the country in Connecticut. I believe it was Connecticut where they're at. Anyway, notice this outdated logo. No mention of what MAC it is. The phone number, like as I said, is in Canada. And you look at the signature down at the bottom of the page, which I don't think you can see it right here. It was Philip Gallipon. Philip Gallipon is not the director of CMS. This right here, Philip Gallipon is a family physician in West Virginia. And they want, and who do you report this to? You report this to the Office of HHS at the OIG for fraud, because this is fraud. CMS is never going to fax you a request for records. A MAC might, with their phone number on it, you can call to verify, but not CMS. So you get a letter like these right here from Optum and these other carriers right here. How do you know they're valid? Does the patient even know them? Do you really think would be a good idea just because you get a fax from somebody to send out all these records to everybody? Imagine what harm they could do to the patient, what kind of harm it could do to your own practice whenever the OIG comes in and says, you did what? I don't think you really want that headache, folks. I don't. So, how about this right here? I created a letter for you. Unauthorized request for patient medical record. We're in receipt of your request for medical records related to patient so and so. After a thorough review of your request and our obligations under the HIPAA, we're unable to release the requested information for the following reasons. There is no direct treatment relationship, and under 506(c)(4), HIPAA permits the disclosure of PHI for healthcare operations only, only when both the requesting entity and the disclosing provider have or have had a relationship with the patient. Our records indicate that your organization, fill in whatever name is there. I mean, it might be Episource, might be Optum, might be Change, might be Codaviti, might be one of those others that you might have never heard of, has not provided treatment or direct services to the patient, and therefore does not meet the relationship requirement. You've also not given me a valid HIPAA BAA that I can look at. Your request does not include a HIPAA compliant patient authorization. You didn't send me something for the patient saying that you have permission to do this. You didn't give me any documentation of a valid BAA with United Healthcare that clearly authorized you to obtain PHI on this. And without one of these, any disclosure I might make would be impermissible. I'm required to take a look at these things. And by the way, your request exceeds the HIPAA minimum necessary standard. You're asking me for a full year's worth of record. Is that really minimum necessary? Now, if you ask me for a specific date, and you asked me to send it to Aetna, which I know has a relationship with this patient, or you asked me to send it to United Healthcare, which I know has a relationship with this patient, that would be a different request. And then I wouldn't have a problem. But you're asking me for a full year's worth of records? Your request for an entire year's worth of records is overbroad, not specific to any clearly identified date of service, medical necessity, or coding issue. We're required by federal law to withhold any disclosure that does not meet that standard, regardless of the payer status or whatever kind of audit it may be. In the absence of a patient-signed HIPAA authorization and documentation of a valid BAA with United Healthcare, and a narrowed request that narrows it down to a specific date. I mean, I'm not going to send you a whole year's worth of records like that because that's not, we're ethically and legally prohibited from doing so. Additionally, we're going to be notifying the employer that sponsors this plan as to your request if it's not authorized. Because why? Because this could place the employer at risk because you're acting on their behalf. You might be the administrator, okay, the plan administrator for their plan, and they are the ones that will be fined, just like you will be, by the way. But the employer is going to be fined, so we feel like the employer should be aware of this right here. If you're able to provide all this documentation we need and narrow it down to that and have us send it to the right people, we'd be happy to review and reconsider this right here. Thank you for understanding that we have this responsibility. I mean, you can use this letter right here and time again. Remember, you're the steward of the patient's privacy information. You're the custodian of their records. So why not send the patient a request on this right here? Dear patient, we received a request from your insurance company or one of their alleged contractors asking for a full year of your medical records. That doesn't really, jive with my understanding. So this doesn't appear to us to meet the minimum necessary requirements. Since it's broad and includes sensitive information, because I mean, it could be including information about the patient's anxiety or depression or mental health, or it could just be about their medications. I don't know. There's a lot of information in the medical record. We want to ensure you're comfortable with this disclosure. Please let us know if you approve of us sending this information or if you'd prefer we limit the release. We'll ask the insurer for more specific. And yeah, you can tell the carrier you're requesting permission from the patient. In fact, I think it's a good idea to do so. Well, remember, if the insurance carrier is doing things that's going to get you or the employer in trouble or risk the patient's data and information, it's up to you to make sure that you're the one that's getting the information or you have the permission to release that information. And I don't know if you're aware of it or not, but the federal government keeps track of, on the Office of Civil Rights, the insurance companies and the providers and, well, covered entities, even the pharmacies or clinics or hospitals, etc., that have had breaches of HIPAA. Just like, everybody knows about the big breach with Change and Healthcare and Optum and United Healthcare a couple of years ago out here, and unbelievable number of records was disclosed, and we still don't know what kind of problems that's going to cause. They have what's called a wall of shame. So don't violate the HIPAA because you could end up being put on that wall of shame. You say, if I want to look at it, where can I go? Well, this is a link right here where you can go to and take a look at it and see exactly what the insurance companies, what the Office of Civil Rights is saying that people violated. For instance, take a look at this page right here. And this right here was, and you'll notice the most recent submission date on this was June 18th. And I'm recording this in July, so whenever I made this slide, I took the current page, the first page off of it. And in Missouri, you got Iron County Medical Center that had a breach with 10,239 individuals and their healthcare provider. And there was a hacking or IT incident. I mean, there's a lot of bad players out there. They're not just all in Russia, China, wherever. I mean, I don't know honestly where they're all at. And the location of the breached information, let's do an email, I guess. Then you've got Winkler County Hospital District in Texas. They only had 637 people, but keep in mind, if there's more than 500 people, they've got to be reported right here. Like Diversified Service Enterprises was 501. Sometimes it's a lot of folks, like Central Kentucky Radiology. They got hacked and apparently 166,953 records. Now, what all was taken, I don't know. Scroll on down there on the page right here, and you'll see down there towards the bottom, Episource. The same people they're asking you to share information with, lost 5,418,866 individuals were affected by this right here through a network server hacking incident. Episource. Blue Shield of California. I mean, and the list goes on. Next page, Sharp Community Medical Group up there in California. Some of these right here get to be pretty big numbers. So Ruco, never heard of them, but they had 240,000, and Select Medical Holdings, I don't know who they are. This goes on and on and on, and there's page after page after page. And these right here are just in the last couple of months, June and May. So these numbers can add up on these things right here. You really don't want to be getting into trouble with this right here. Um, Sometimes the carriers will come in and tell you, though, hey, if you don't provide these records to us, we're going to go back and take the money back from you, Doc. Now, you may sit there and say, do they really threaten that? Usually not on the first request. On the first request, they'll sit there and say, hey, send us these records. We're entitled to these records in the letter, and they'll even reference in there per HIPAA laws 164.501 or .506. We're entitled to have this, and you're not required to go back and get the patient's authorization. Sometimes they'll even lie on those and say you're not allowed to go back and get the patient's one. Excuse me, I'm not allowed to? Read the letters kind of carefully because some of these letters were not drafted very well. And some of these letters, like I said before, may not even be coming from the insurance company. They could be coming from another source. I remember one time that one record request I saw was asking you to send all these records right here to a source in Georgia. And if you look at that source, it was a FedEx Dropbox. It wasn't even an insurance company's address. So check this stuff out. And with the Google being what it is today, you can log in and put in somebody's address that they're asking you to send these records to and find out whether or not it's valid or not. Sometimes they'll sit there and say, well, upload them into our portal right here. And how do we know their portal is secure? You just saw a moment ago, Epos at 560, no, it was at 5,660 something records, 660,000 records that were hacked. Is it legal, by the way, for them to issue a retroactive denial? They want you to believe it is. Now, who can issue a retroactive denial and who cannot? There's federal laws regarding that. In fact, Medicare can issue retroactive denials beyond the 30-day time frame. But can commercial insurance carriers? Well, that depends on whether or not they're asking for money back, et cetera. Now, there's different laws and different regulations out there. For instance, sometimes you may get a letter from an insurance carrier that comes in that says, "We overpaid you." One of my clients just got that on 3 different claims yesterday, and they called me and said, "Hey, this insurance company is saying they overpaid us." I said, "Well, did they?" She said, "What do you mean?" I said, "Did your notes support 2 of those were hospital visits and one was a hospital discharge? Did the doctor document the amount of time? Because he billed a 99239. And if he didn't document the time in there, then they were correct in saying that we should have only paid you on 99238. So they may be asking for the money back. And is that legal? Well, yeah, if you didn't document it to that level, you billed the wrong code. But are they allowed to come back and take the money back automatically? No. Are insurance carriers ever allowed to come back in and do a recoup from you? No, not commercial insurance carriers are not. He said, but they do it all the time. That's because 95% of the people in the healthcare field do not know what the laws are. And if they don't know what the laws are, then the insurance carriers are going to get away with it. Back in 2001, a case was presented to the United States Supreme Court on a Great West Life and Annuity Insurance Company. And the late Justice Scalia came in with a decision right here. The Supreme Court made a decision, but Justice Scalia is the one who wrote it up. It said a plaintiff cannot enforce a constructive trust or equitable lien upon other property of the defendant. You said, what does that exactly mean? It means they cannot come in and take money back from other claims. Oh, okay, from the doctor. In other words, who can they recoup from? The patient only. And several cases have popped up since the 2002 case. Well, it was 2001 presented to the Supreme Court, and in January 2002, they made their decision. They're also prohibited from cross-plan offsetting. You say, what is that? I'll give you a good example right here. I've got a podiatry group up in Arkansas that's on a retainer with me. And the Medicare, an insurance company was coming back and taking money back on some Medicare claims and some other insurance claims for different different employers. And they're not allowed to do that. That's called cross-plan offsetting. Insurers and health plans must comply with all applicable federal laws. You say, does this mean that I have to take them to court? No. When you reach out to the CEO of the insurance carrier and say, you are now in violation, we're going to be notifying whoever it is. Like in the case of employer-provided insurance, we're going to notify the Department of Labor, EBSA, that you are violating the regulations. Well, what does the EBSA and Department of Labor have to do with my insurance claims? If an insurance policy was provided by an employer and the employer is taking care of that employee, okay, and that's part of their benefits, their employment benefits, just the same way as their salary is, the retirement plan, days off, any of that right there, that's all part of the retirement. I mean, that's all part of the employment compensation package. Then the Department of Labor, under the EBSA division, comes into play. So that's called ERISA, the federal ERISA laws, as well as statutory fiduciary duties. Before they can ever recoup, they've got to meet all the laws. So what does the law say? The law says they cannot just deny claims, first off, anytime they want to. They have federally mandated deadlines. What do you mean deadlines? Well, if you go over there and look at section 2560, again, you can pull this up into the Code of Federal Regulations right here at the link. And in fact, I've given you a Cornell Law Education link to this specific page. In the case of a post-service claim, and that's what you guys are filing, you've done the service, now post-service, you're now filing the claim. The plan administrator in every policy has a plan administrator that's required by law, and that plan administrator, by the way, is personally responsible and liable for making sure they follow the regulations. And if they don't, they can be fined and jailed. They shall notify the claimant in accordance with the paragraph G of this section of the plan's ABD. What's an ABD? That's if the carrier doesn't pay for the claim in its full charge as the full amount that was billed. It's an ABD. Within a reasonable amount of time, but not later than 30 days after the receipt of the claim. You say, Don, I'm a little confused. Okay, let's look at it this way. You filed a claim on June 10th. Today is July 10th. Has the claim been denied or paid yet? Well, no. They're required to within 30 days. They must issue an ABD or pay the claim within 30 days. Now, they can get an extra 15 days, but only if they request that prior to the expiration of the 30-day period. So today's 30 days. If they have not requested an extension, they're required to pay the claim because they cannot issue an adverse benefit determination beyond 30 days. But you say, what if they want to lay 2 months later, they come back and say, well, we shouldn't have paid this claim. That's an adverse benefit determination, and it's beyond the 30-day guideline. And do the insurance carriers know this? Yeah, they know that. Do the doctors know this? Maybe 3 or 4% of the providers watching this right here know that law. I use this all the time to beat insurance companies. Hey guys, this is the law. Follow the law. Okay. And by the way, if the insurance company breaks the law, who's going to get in trouble, by the way? The employer. Why? Because the employer is the one that has the final fiduciary responsibility of following the Department of Labor guidelines. And the employer is the one that selected the insurance company. And they may have even made the insurance company the plan administrator, or it might be the CEO of the the employer might be the plan administrator. But whoever the plan administrator is, they're going to be the ones going to be in trouble. But what if we're talking about Medicare? What if the one's asking for medical records, Medicare? Medicare plans have to follow the HIPAA laws also. But remember, when you're standing firm on HIPAA, you're not standing alone. You've got all these other people behind you. Speaking of Medicare, by the way, and these denials, I've just gotten a letter this morning from a client of mine, a retainer client, or a membership client of mine up in Illinois, saying Humana has been downcoding their level 4s to level 3s without requesting the records and even looking to see whether or not they were level 4s, etc. So I shot off a letter to them this morning. I'm sure the administrator of that client's going to love this one because we're reporting them to the state representative since there is an investigation going on by the House of Representatives, as well as Senator Doggett, who's the chairman of the House Ways and Means Committee that's investigating in Medicare Advantage plans for doing that same kind of thing right here. The state attorney general there in Illinois, because that's a violation of the Fair Trade Practices Act in Illinois, as well as CMS, because they're violating CMS Medicare Part C regulations under 422.100 Code of Federal Regulations there as well. So remember, when you're standing on HIPAA, you're standing on your rights. You're not standing alone. So who can file a complaint? Anybody can file a HIPAA complaint. It's not just the individual. You can file it on behalf of you. You can file it on behalf of the individual. If you believe that a HIPAA covered entity or its business associate violated yours or someone else's Health Information Privacy Acts, you have really a responsibility to file a complaint with the Office of Civil Rights. So where can you go to do that? Well, there's several ways to do it. You can do it in the mail. You can do it online with an email. You can do it under fax number. You can do it under on their portal. And this page right here gives you all the ways that you're able to file that complaint with them. And should you do it? Yeah, definitely do it. Remember, if you don't do this right here, these insurance carriers, whether or not they're Medicare or whoever they are going to continue to violate that patient's HIPAA rights. And you're going to keep getting all of these medical record requests. You said, but can they kick me out of their plan? No, that's called retribution. And that's a violation of federal law also. So I can be kind of a whistleblower. I don't know about a whistleblower. You're not sitting there trying to get some kind of a whistleblower bonus out of the key tam laws. What you're doing is just following regulations and holding the carriers responsible for following the law. So I'm giving you ways to right here to report HIPAA complaints right here to the Office of Civil Rights right here under the HHS. Mail it to them, email it to them, do it online, or even just fax in the complaint. You say, is that legal? Yeah. Remember, this is the government. They have the authority. They have the responsibility to make sure that they act on this. But what if it's a Medicare one? Cool. Notify Medicare. If it's Medicare carrier, sometimes will come back and make a threat. Well, if you don't give us this records, we're going to recoup this from you. They love making that claim, it seems like. But that is a violation of several things. That's a violation of federal regulations right here because it's an improper threat. They're basically misusing medical necessity of forced data sharing. It's a failure to follow HIPAA limits, etc. So you can report them to Part C compliance, cms.hhs.gov. Include your NPI practice info specifics of the threat. Medicare, and if your email is not protected itself, it's not HIPAA secure, then you may want to attach something in there that is password protected or ask them, how do you want us to report this patient's information to you? Remember, work in coordination with HHS and OCR whenever violations include HIPAA, because HIPAA and OCR all works under the HHS, okay? And so use those folks right there to reach out to them. This makes a difference, folks. It really does. What about state attorney generals? You can find out who your state attorney general is and their mailing address just by going to this usa.gov state-attorney-general. And then you can put in your state and it will tell you. See, there's 56 state attorney generals. You say, well, okay, hold on, Don. My name ain't Obama. I don't think there's 56 states. I know that, but there's 56 states and territories of the United States because Guam has one, Puerto Rico has one, etc. And again, Washington, D.C. is not a state, but they have an attorney general. So there's 56 attorney generals. Remember, it says right here, most states have consumer protection laws modeled after the Federal Trade Commission Act. In fact, this letter I sent this morning to my client up in Illinois gave her the address for and the name of her state attorney general. And it even references the Illinois Deceptive Trade Practices Act, which is modeled after the Federal Trade Commission Act. And these unfair and deceptive act and practices, that's what they're doing. When they threaten to recoup this because you're not following federal law and they're asking you to violate federal law, it's up to you to make sure you report them. And every state has these almost. But I think 34 states, something like that, have specific Deceptive Trade Practices Acts. But the attorney generals want to know about this stuff right here because they love going after these insurance carriers that's violating these things because they're tasked with protecting the consumers, and that's your patients right here. And it's considered to be coercive, retaliatory, and unfair trade practices for them to be making you try to violate HIPAA. And if you don't, then they're going to take money back from you? No. Now, notice here, Texas Deceptive Trade Practices Act. I got the California one there and listed out, the New York one out here. So I've given 3 of them out here, but you can find these really easy. So what are you going to tell them? As a licensed medical provider, I was threatened with payment recoupment by so-and-so insurance company for refusing to send a full year's worth of patient records to a third-party name, an entity with no direct care or coverage relationship with the patient. I believe this violates HIPAA. And it violates the minimum necessary rule as well as the entity relationship under 164.506. I believe this threat constitutes coercion and violates the Texas Deceptive Trade Practices Act. And here in Texas, we have a go-getter attorney general. He loves to go after these insurance companies on this kind of stuff. So whoever it is that's in your state, make sure you report it to them. Make sure you report it going back to the House of Representatives, for instance, like those on Medicare claims. The Senator Doggett, as I mentioned earlier, is over the I believe it's deceptive trade practices of Medicare carriers regulation of 2025. They're trying to pass an act on that right there so they can go after Medicare carriers that are violating the regulation, Medicare Advantage plans as well as traditional Medicare Max. That's all falls under the federal feds. So reach out to Senator Doggett and say, hey, Senator Doggett, I think his territory is Austin, Texas, Travis County down there. But send it to him in Washington, D.C. Send it to CMS. They want to know whenever these carriers are violating the regulations right here. If it's commercial plans right here, send it out. If it's being insurance provided by an employer, send it out to the Department of Labor. In other words, the more people you send this to, the more these carriers are going to start realizing, crap, we can't keep doing what we've been doing. We cannot keep just being a bully and stealing the money. And that's what they're doing, basically. They're stealing the money from you. Unfortunately, you and just about everybody else have been letting them do it in the past because you didn't know what the regulations were. And that's where I come in. And I'm not an attorney, folks. But doggone it, I've been a small guy all my life with a big mouth, so I got beat up countless times throughout my life in the grade school, junior high, high school. Not after school, because after that I went to the Navy and I learned how to defend myself. But growing up, I got beat up all the time, and I hate bullies. I hate bullies with a passion. I know Jesus tells me to love everyone. I can love them, but I sure don't like their actions, okay? So stand up to these people right here. If you need additional information about how to use ERISA and how to stop the carriers from downcoding and how to stop the carriers from recouping and what the 30-day limit is and how to write the letters and that stuff, I've got the letters in the book already, the Unfiltered Guide to ERISA Medical Providers. It was updated this year, by the way. And I have clients all the time copy these letters and use them. I like this letter right here, but I have dozens of testimonials from people saying this works. I've been using Don's methods from his webinars and books. We've stopped every single overpayment request, every single one. Staff estimates about 270 times. The payers know we're going to call them on their BS. We literally get clients contracting us just to write letters. David Martinez, really smart man. He's got a big following. I think hundreds of thousands of people follow him, and he does billing from all over the country right here. And if you want to verify, you can email him. And if I can ever be a consultant to y'all to help you, I'll spend 90 minutes on the phone with your office. I need the medical provider on the call. I need your doctor on your office manager, your biller on the call, asking questions and making suggestions. At the end of that time, I'm going to ask you a simple question. Hey, Doc, do you think I just helped you increase your income by $100,000 a year? And if you say, yeah, you're going to pay me my $1,000 for today's consult. And if you say no, you don't owe me. That's how I've been doing business now for, well, almost 40, well, over 40 years, I guess, a long time. And it works. So you really have nothing to lose. I hope this has been helpful to you, but if you learn one thing, learn to stand up for what, well, for your rights and the patient's rights. Stand up against these insurance carriers. If we get enough people standing up, then guess what? You're going to win on these things. And I've got another webinar I'm in the process of creating right now about why it makes more sense for you to drop out of every Medicare Advantage plan, every Medicare Advantage PPO plan, because they're going to have to pay you more. They still have to pay you for every service, but you don't have to do the pre-authorizations. That's a whole nother webinar I'm creating. I'm hoping to be able to record it within the next week or two and have it out there on my website. In the meantime, thank you for spending the time with me. I would love to hear what you think of this webinar. So send me an email saying, hey, Don, it was confusing, or Don, you've simplified it, or Don, this has helped me, or whatever. Okay. I would love to hear that. My email is donself@donself.com. And if you ever forget my phone number, It's easy. 877 Don Self. Okay. Y'all have a blessed day, and thank you for allowing me to serve you today. I hope that this has been a blessing to you in some regard. Bye bye.